Coming up next on Arizona Horizon, we'll update the legal fight over a proposed tribal casino near Glendale. Also tonight, the Sierra Club reviews new state laws impacting the environment. And an attorney for the state's redistricting commission talks about the Supreme Court's recent ruling on voting rights. Those stories next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. A federal judge last month ruled that Arizona's gaming compact does not prohibit more tribal casinos from opening in the Phoenix metropolitan area. That's good news for the Tohono O'odham tribe and its plans for a casino near Glendale. Heidi McNeil Staudenmaier of the law firm Snell and Wilmer is here to help us make sense of this latest ruling. Good to see you again.
Thank you.
What exactly did the judge rule?
Well, the decision back in May pretty much decided most of the claims that were out there, but he left two claims alone, which he felt like needed additional briefing on. And those specific questions were, does the restatement of contracts, which is a statutory legal thing, apply when a party's understanding of the contract is not reasonable? And then secondly, which representatives of the state should we look to decide what the state understood when the compact was entered into? Should they look to the intent of the governor, the voters, or somebody else? So those two issues were sent back to the parties to brief, and that's what he then looked at and reviewed in this most recent decision.
Let's start with the idea of what was understood by this gaming contract. What does the gaming compact say regarding new casinos?
Well, that's what the judge, that's basically the crux of the whole issue of the lawsuit, is what does this compact, which is 67 pages long, 26 sections, a very in-depth legal document, and that was part of what the judge was commenting on, was this compact was negotiated for a long time by some very smart people, and I don't see anywhere in this document that says that there will be no more new casinos in the Phoenix area. And that's kind of what it boils down to, is where in the compact does it specifically say there would be no more casinos in the Phoenix area for the Tohono O'odham tribe? And the state and the other plaintiffs argued that, well, there's other evidence out there. There's understandings that the state had, there's understandings that the Tohono O'odham tribe had, that they knew that when they were entering into this compact that they were implicitly agreeing that there would not be any new casinos in the Phoenix area. And they were a tribe in Tucson.
So is the judge basically saying implicit is one thing, but I don't see it here in the compact?
Well, in this most recent ruling, he looked at those two discrete issues, and the most important thing that he determined right from the start was, he said, okay, I understand there may be evidence out there about what the tribe understood, what the state may have understood, but he looked at the four corners of the contract. He also looked at Arizona law, which has a very liberal interpretation of how you interpret letting in other evidence that's not in the four corners of the contract. And even notwithstanding that liberal interpretation, he said this is an integrated contract. What that means is that all of the important terms are contained in the four corners of this contract. Therefore, it really doesn't matter what other understandings may have been separate and apart from this contract.
With the idea being that because the contract is so firm and it's all right there, if you didn't understand, where were you?
Why didn't you put it in there?
Yeah.
Exactly. And, you know, there was a lot of discussion in the briefing about, well, you know, the Tohono O'odham truly knew that they wanted to have this casino, but yet they didn't bring that up during the discussions. And so, you know, the judge really did a very thorough examination. He looked at all this extrinsic evidence, and at the end of the day, he said, you know what, this contract stands on its own, and it's not a reasonable interpretation to say otherwise.
It cannot reasonably be read to include such a ban, period. Now, the second part is who was supposed to do the understanding?
Well, that's kind of a secondary issue, even though that was one of the issues briefed, because in the judge's final analysis, it really didn't matter whose understanding was, because he said that a separate oral agreement that's separate and apart from this integrated agreement really is not reasonable to include in my analysis.
So if the governor thought this, the voters may have thought that, a couple of lawmakers thought this, Attorney General said, everyone's thinking all over the place, but the contract says X, Y, and Z. Doesn't matter what these other people are thinking.
That's pretty much how the judge came down with his ruling.
So what happens from here on this?
Well, I haven't heard specifically, but I would assume that the plaintiffs, the state and the other tribes, are contemplating appeal. If they do appeal, the next step for appealing would be to the Ninth Circuit Court of Appeals in San Francisco. So they file their notice of appeal and go through that process, and it's possible if they go through that process, and depending on how that comes out, it could ultimately be appealed all the way to the United States Supreme Court.
And again, the basis of their appeal would be similar to their argument in this particular case, and that is we understood X, but we didn't get it in the compact?
Well, it would be their entire, this case now is done. They had a lot of claims in the case. The judge entered summary judgment on every single claim now. So for going to the Ninth Circuit, I would assume they're going to look back at the claims and determine which are the most powerful claims and put their best case forward. But obviously they have to get through this judge's analysis, which is pretty solid.
Now, as far as I know that Glendale's had this effort to annex land. That is in court as well. Where does that stand?
Well, that lawsuit was sent back to the Secretary of the Interior, who had made a decision, it was either earlier this year or last year, about taking the land into trust, saying that it did qualify under the federal statute that's applicable here, but they want the Secretary, the judge in that case, wants the Secretary to take another look at it and determine whether or not, because this land is surrounded by the city of Glendale on three sides, whether that somehow takes it out of the category for qualifying. You know, so the Secretary is going to have to re-examine that issue and make another decision in terms of whether the land should be taken into trust, or maybe the Secretary may make a totally different decision.
So right now, the city is enjoined and blocked from annexing the land, and the tribe is blocked from taking it into trust until Interior Department figures this out. And the Interior Department has to, it sounds like it's a county. Don't we have county islands all over the place?
I would suspect we do.
Yeah, so from a distance, it sounds somewhat similar. So I guess we'll see how the Interior Department does on that one. Thank you so much for your help explaining all this.
Thank you.
Good to see you again.
Thank you.
We want to hear from you. Submit your questions, comments, and concerns via email at arizonahorizon@asu.edu.
The Grand Canyon chapter of the Sierra Club is not giving state lawmakers high marks for their work on the environment in the past legislative session. Sandy Barr, director of the Grand Canyon chapter of the Sierra Club, is here to explain. Thank you so much for joining us.
Pleasure to be here.
What kind of year? Doesn't sound like you were all that pleased by what happened this go-around.
It was quite disappointing. We started out the session expecting that the legislature might, step up and address some of the environmental problems we face, promote renewable energy, energy efficiency, at least do a few things to protect air, land, and water. And the whole session was spent trying to stop bills that undermine protection.
The whole session also seemed to be dominated by Medicaid expansion. Did that play a factor in some of the laws that you were either wanting to see or wanting to see blocked?
Oh, sure. I think that legislators were not as focused on, and in some ways maybe that's a good thing because there might have been more bad bills, but they certainly weren't as focused on environmental protection.
I did see a funding increase for state parks. That would be a good thing, I would think.
Yes, there was some additional funding that was included in the budget bills for state parks, and that's a positive, especially because parks have been hit really hard over the last several years. They didn't sweep the parks funds, but they also didn't reinstate a fund that they took away, the Arizona Heritage Fund. They had swept that and also repealed it a few years ago, and they didn't reinstate it now that the budget was looking a little better. So that was disappointing as well.
So still no dedicated funding source?
Nope, no. And so every year it's a struggle to keep our parks funded.
Let's take a look at some of the bills that I know you were focused on yourself. The health and safety audit privilege. What was that all about?
Well, last session they passed a bill we called the Polluter Protection Act, and what that bill did is allowed companies to do an audit and keep information in the audit secret, and that focused on environmental protections. This bill expanded that idea to health and safety protections. So if a company does an audit, they find violations of health and safety laws, harm to people even, they get to keep that information secret in this audit, and none of that information can be used in any kind of civil proceeding, any kind of fine or action against the company.
I know the rationale for this, though, was that it provides incentives to do internal audits and to fix those problems without having to worry about what comes later. Valid argument there?
Well, we don't have a problem with programs that actually do provide incentives for doing the right thing, but this type of program is the wrong direction. It provides a shield of secrecy, and it really protects the bad actors. So if you had repeat violations or you were doing things consistently to harm the public, you could hide it in these audits. And we think Sunshine will bring more environmental protection and protection of our health and safety.
But if they're not hidden in these audits, fair game.
That's correct, but if you're a big company and you have a lot to hide, you're probably going to be doing an audit.
The use authority of off-highway vehicles, what was that one all about?
Well, that one was partly Arizona Game and Fish having a power struggle with the federal government, but the bottom line is the bill allows Game and Fish officers as well as the sheriffs to ignore harm to public lands, especially public lands that have been protected from off-highway vehicles. So say there's somebody ripping up a wilderness area or a river or stream, important wildlife habitat, they can't actually do any enforcement if it's on public land that has been closed to off-highway vehicles.
Okay, are you saying they can't do any enforcement, or it gives them flexibility to choose whether or not to enforce?
No, it's actually prohibited on the closed lands. They have the option of enforcing the wildlife habitat protections on any land, but on the closed lands they can't do enforcement.
I know that the county sheriffs and Game and Fish were very much responsible for this bill. Why were they so much for it?
Well, Game and Fish didn't get everything it wanted from the Forest Service in one of the travel management plans, and so it decided to say, you know, we're not going to do enforcement. And the very sad thing about that is they went back on an agreement. There was a bill several years ago where they got funding for 7 full-time officers to do specifically off-highway vehicle enforcement, and now they're going back on that agreement.
So when Game and Fish says that the new rules, these new federal rules that many thought were too restrictive and that thus the bill addressed, that they put unreasonable restrictions on hunting, on fishing, and on camping, you would say? Not
at all. Not at all. They protect resources, and in fact a lot of people who hunt, fish, and camp don't want to have an ATV driving through the middle of their campsite. They want a little bit of quiet recreation. But ultimately what we're talking about is protection of resources, protection of wildlife habitat, and having off-highway vehicles ripping up habitat and disturbing wildlife. That's not going to be good for hunters or for the wildlife overall.
Is there a middle ground from what you would like to see and what the federal restrictions are and what this bill, what this law does? Is there some compromise in there somewhere?
Well, there's a lot of land that's open to off-highway vehicles out there. There are a lot of roads throughout our national forests, the Bureau of Land Management lands. So there are a lot of places that people can go. There are some areas that are closed, and they're closed to protect resources.
I know Sierra Club was also very interested in the change to citizen initiatives and referenda. Explain, please.
Yes, House Bill 2305, which was an end-of-session bill where they did the Christmas tree approach. They put everything but the kitchen sink in there. The bottom line is initiatives and referenda, they're an important check on the power of the legislature. And so the legislature has never liked them. I mean, they would like more power. And so each session we see several bills that aim at weakening citizens' rights to initiative and referendum. This session was no different. A lot of them didn't pass. This bill basically makes it more difficult to put an initiative or referendum on the ballot. It makes it easier to throw things out on a technicality.
Last question. What didn't pass that you see as a victory?
House Bill 2404, which was a bill to weaken energy-efficient building codes. It was a measure that basically prohibited local government from implementing strong building codes. And these energy-efficient building codes save a lot of money. They save consumers a lot of money. They save a lot of energy. That results in less pollution, less water use. It's a win-win-win. And this time, the home builders did not get that bill through. So
were you surprised by that?
I was very surprised by that because the home builders usually get what they want from the Arizona legislature.
We have about 30 seconds left. What do you want to see? What are you gearing up for the next session?
Well, what we would like to see is legislators step up and look at our parks and look at energy issues and say, how can we do better? You know, Arizona's a sunny state. What can we do to help promote solar energy in our state? How can we help ratepayers, individuals in their homes, save energy and also reduce pollution? What can we do to protect our parks and wildlands? And by the way, how about if we reinstate the Arizona Heritage Fund? $10 million that they swiped, that the voters had approved, time to put it back and fund things like trails, historic preservation, protection of cultural resources.
All right. Sandy, thank you.
Thank you.
The U.S. Supreme Court recently ruled against a provision of the Voting Rights Act that required some states, including Arizona, to get pre-clearance from the federal government for changes in election laws. The Arizona Independent Redistricting Commission draws maps for congressional and legislative districts and was subject to pre-clearance. Joe Canfield, an attorney for the commission, joins us now to talk about the impact of the ruling on the commission. Good to see you again. Thanks for joining us.
Thanks, Ted. Thanks for having me.
What are your thoughts on this pre-clearance ruling? Surprised?
No, because the court had already decided this question a few years before, where they had at least telegraphed that they had some concerns about the viability of the pre-clearance requirement in a decision about 5 or 6 years ago. So this decision actually teed it up and struck it down. So it did not come as a surprise.
And again, pre-clearance meaning have to get, if you're going to make election law changes, any election law changes, got to get the Department of Justice federal approval first.
Correct.
Okay, with that in mind, the Redistricting Commission has to get federal approval first and has to keep federal guidelines in line. What does this ruling do to the Commission's efforts?
Well, at this point, the maps are done. So the Commission drew its maps, the congressional map, the legislative map. Those maps were pre-cleared by the Department of Justice in 2012 for the first time in state history since we became a covered jurisdiction. And so at this point, you know, the maps they're constitutional. They're the maps that will be used for the rest of the decade. And unless there's a court ruling otherwise, they are our maps.
Is that the only way that they could be redone, is by way of the court rulings? We got one out there already. By the way, something happened with one of the court's decisions, one of the court legal actions out there?
Well, today we received an order from the federal court. So remember, the federal court, there's two court actions. There's a state court, a federal court proceeding. The state court action challenges the federal map, the congressional map. The federal court proceeding challenges the state map.
Convenient.
We had a trial in March. It ended at the end of March. We've been waiting for a decision from the federal court on whether or not the state legislative map is constitutional. And that case was primarily a challenge based on the Equal Protection Clause, because not all the districts were the same population. So the argument was that because there's a deviation and they have to be justified, and the plaintiffs don't believe they are. So trial ended in March. Today we received an order asking for briefing from both parties on the question of what impact or what effect the Shelby County case, the U.S. Supreme Court case that struck down the coverage formula under the Voting Rights Act, has on this case. So we will now have an opportunity to brief the court on this question over the next 3 or 4 weeks.
So there is a possibility that more drawing could be done, and if more drawing is done, this ruling does play a factor.
Well, it could.
It could.
It could, yeah. I mean, remember, at all times during this drawing, Section 5 of the Voting Rights Act was the law of the land. So the Commission was striving mightily to comply with Section 5 and was successful. At this point, if Section 5 is no longer the law of the land, then and we go back to the drawing board, well, then we'll have to wrestle with what impact this ruling has. But something that we mustn't forget under the Voting Rights Act is just because Section 5 may no longer be effective, Section 2 still applies. That means you can't violate the Voting Rights Act. There's still a cause of action, so the Commission would still have to comply with the Section 2 of the Voting Rights Act.
So basically, you don't have to necessarily get pre-clearance, but you still got to follow the rules.
Right. I mean, pre-clearance has shifted the burden to certain covered jurisdictions, including the state of Arizona, that before any election law, procedure, policy goes into effect, you have to prove to the Department of Justice or the federal court in Washington, D.C. that it would not have a retrogressive effect on certain language minority groups. And if you made that showing of proof, well, then your law could go into effect. Well, now the law goes into effect. If someone believes that there would be a discriminatory effect upon these language minority groups in Arizona, well, then they could bring an action, and if that was the case, then the court would strike it down.
Regarding these minority requirements, and it seems, again, it looks from a distance like that would change somewhat. How do things like communities of interest and those other provisions apply? Do they become more powerful as opposed to the minority requirements?
Not necessarily, because the way that the drafters of the constitutional provisions that govern redistricting in Arizona, the way they drew those or set forth those provisions, they said you had to comply with, of course, the United States Constitution, the Voting Rights Act, to respect communities of interest, geographic boundaries, competitiveness when practicable. So all of these factors still have to be taken into consideration, not just by this commission if they have to go back and redraw these maps, but all future commissions while these constitutional provisions remain in effect.
You mentioned that this was the first time that the maps had been drawn and got immediate approval from the Justice Department. 2 previous times, no. Does that suggest that this pre-clearance is somehow needed?
Well, that's a good question. Obviously, I'm sure that there are certain people that would articulate a very good argument as to why it's still necessary. I mean, those arguments were compelling within the federal court system. The courts below the U.S. Supreme Court held that they should still be in place, that we haven't advanced past the wrongdoings of the past that require them. My experience as a former election official were that most of the time this pre-clearance requirement prevented us from implementing very technical changes to the law that now will help our elections run much more efficiently, because there won't be that burden on the front end that took up some time. And a lot of times these election laws and procedures are being put in place shortly before the election, when election officials are really under the gun to get everything in order. So, my hope is that not having the pre-clearance requirement in Arizona will help our election officials focus on things like reducing lines at the polls and counting ballots faster and stuff like that, without having that requirement distracting them at the front end.
Very quickly, would you be surprised if either of these suits, the federal or the state suit regarding legislative or congressional maps, would you be surprised if either one of those goes back to the commission?
Well, remember, I'm counsel for the commission, so
yes.
Of course we've been in court advocating against these lawsuits.
Yes.
And so we, of course, take the position that what the commission did was wholly in compliance with the federal constitutional, state constitutional requirements, and that the right decision would be to uphold these maps and not force the commission back to the drawing board.
All right. Good to have you here. Thanks for joining us.
Thank you, Ted.
And that is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.